Hello, everyone. Welcome to Immigration and Jobs Talk Show. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, once again, guys, welcome to Immigration and Jobs Talk Show. And today, our topic is going to be very informative. That is how changes in the jobs of foreign national employees impact visa status and green card process in the US. So, we all know that in the US, foreign nationals working under various visa categories. And they too face some unique challenges when it comes to their employment status and green card process. And understanding how these changes can impact a foreign national's visa and green card journey is a crucial for both employees and the employers. So today we are going to talk about it and have a detailed discussion on this. And the great thing is that we have an expert here today with us. Please join me in welcoming an immigration attorney, Kimberley Best Robidoux, who is specialized in counseling corporate clients on immigration and related business matters, visa matters, as well as employment based immigration petitions. So, Kimberly, welcome to Immigration and Jobs Talk Show. It's a pleasure having you again with the second episode of today, and thank you so much for joining us.
Yeah, it's great to be here with you, Sam. Thanks so much.
Me too, me too. So, Kimberly, before diving into our questions, I would like to know that from today's episode, what our viewers can expect.
So, we're going to talk about what happens if there are changes in someone's job, for instance, a change in a work site or a change in the job position or a restructuring of the organization. So, we're going to talk specifically about some impacts on some types of visa classifications as well as on the green card process. So, just kind of give a general overview so people are aware of what to look for so that they can help, protect their status in the United States.
All right, all right. That's great. And thank you so much, Kimberly, for giving us a brief about today's episode. So, I think let's begin with our very first question that I would like to ask from you. And that is what happens if a foreign national employee receives a significant job change or promotion? Do you think that this is going to impact their visa or green card process?
Yeah, if someone is receiving a significant job change or a promotion, one of the things that we want to look at first, what the company should do, and the individual should also, be concerned with this as well, is what is the specific visa classification that someone is on in the U.S. So is it an H-1B or a TN or an O or an E3, right? Any of those may have different situations that could impact their visa classification differently. So typically, a significant job change, which is usually described as a change of job duties by at least 50%, would typically require the filing of an amended H-1B petition before taking that job change. With an E3, that also would require an amended E3 petition to be filed with the Immigration Service. With a TN, that may or may not require an amended TN application or petition with the Immigration Service. What needs to be looked at for the TN classification, which is for citizens of Canada and Mexico, is whether or not that significant job change is taking them out of the professional occupation under the United States Mexico Canada agreement for which they qualified for the TN. So that takes a little bit, that can be treated a little bit differently and involves, a little greater analysis with respect to the occupation. And then with some of the other visa classifications, such as an L1, again, it looks at is someone in an L1B classification, and the significant job change is essentially putting them into an L1 as a manager or executive, then that would definitely require a filing of a USCIS petition and approval before being, starting that job. So those are a lot of factors to look at, right? What is, is the position change significant? You have to look at the duties in particular to understand if there is a significant job change and how, it will impact the specific visa classification. And then with a significant job change, when we're talking about the green card process, we also want to look at what is the green card process, right? There are many different ways that someone can obtain the green card through employer sponsorship. One is through the PERM labor certification application. And if that labor certification application is under draft or if it's pending with the Department of Labor, then if there's a significant job change, it is very likely that that PERM process will have to start from the very beginning. And that would be defining the role, doing the prevailing wage request, and then recruitment, et cetera. If the job change is something that happens um, after the I-140 immigrant worker petition has been approved based on an underlying PERM labor certification application, then there's a little bit more analysis that needs to be done to determine if the company needs to start over again with the PERM process, or if they're okay to continue to move forward with the already approved I-140 immigrant worker petition. And then, of course, also looking at potential changes in USCIS policy. So for many, many years, if there's been a significant job change, while it might require an amended H-1B petition, it might not have required the starting of the green card process from the very beginning if there's already an approved I-140 petition. But that really depends on, are there going to be any changes in USCIS policy going forward under the Trump 2.0 administration? So again, it's always looking at the basis of the green card process and what are the current immigration policies. If the green card process was based on outstanding researcher, right, the EB1 B classification or category for the green card process, that significant change in the job, while it might require an amended petition for the non-immigrant visa classification, it might not require filing the outstanding researcher petition again. Same with extraordinary ability, which is the EB1A category. And then if someone is a multinational manager and they have an EB1C based on multinational manager with an approved I-140 petition, a significant change in the job may or may not require the refiling of the I-140 petition. So those are some important things to consider. Is not only is there a significant change in the job, but what is the the employment-based preference category on which the green card process is based. So we would look at, as I mentioned, is it based on the PERM application? Is it based on extraordinary ability, outstanding researcher, multinational manager, or national interest waiver? So a lot of times the national interest waiver, multinational manager, outstanding researcher, and extraordinary ability typically will not need an amended petition. But in some instances, and more likely, there will be a new process required under the I-140 based on the PERM labor certification application. So Sam, there's a lot of information that we just kind of talked about there.
Yeah.
So yeah, it does. It's all based on the particular visa classification and the employment process. So it's always a good thing to do that deep dive, do the analysis, work with the company, and the company work with the individual and the attorney who's assisting the organization in order to determine how will a significant job change impact the green card process or the current status before any changes is taken, right? That's the whole thing, is to get ahead of it, understand how it can impact the process.
Absolutely. And I think that's wonderfully explained. And thank you so much, Kimberly, for taking that up and explaining it in a very detailed way. So, also, Kimberly, I would like to know that you have been through, so many clients, and they might have some kind of real life situations that might be related to our today's topic. So, would you like to share any experience of your client who have been through this, and how did you handle it?
Yeah, so I mean, we've had situations in the past, especially for individuals that were born in India or China, where the green card process can take a really long time. So what happens is that we want individuals to be able to grow in their career, which in many instances requires or it creates promotions, and those promotions can have an impact on the green card process. So in one particular case, we had someone who had been in H-1B status for many, many years, already had an approved immigrant worker petition and was waiting to file the adjustment of status application, and then was receiving a big promotion. So we worked through the timeline to see, is there enough time before the green card process will be ending And in that particular case, it was going to be another at least 4 years based on the visa bulletin. So what we did is we worked through the case in order to do an amended H-1B petition, and then we were able to use the employees' experience that they had gained at their sponsoring employer to qualify for the new PERM labor certification application, which had to be filed. And then when the I-140 petition was approved after the labor cert was certified, we were able to retain the priority date from the earlier I-140 petition. So it worked out in that situation, and that the individual was able to grow in their career, accept the promotion, move into the new position. And it did unfortunately require the amended H-1B petition and starting the green card process early again, but it was something that allowed the person to continue in their promotion, so that was really successful. So that's a real life example of one of the cases that we've had to work through.
Wow, that's wonderful. So I'm sure, and you handle these cases wonderfully. So it's been great, and also to know your experience. This, I think, our viewers are also getting to know about it. So that's very informative too. And moving ahead, Kimberly, I would like to know this answer: that if a foreign worker changes jobs, then does their visa automatically transfer to the new job?
Yeah. So if an individual, and I'll use the job being if they change employer, right? So if an individual is changing employer, that new employer has to file a petition or an application for them in order to work at that new sponsoring employer. So the H-1B is not automatically transferred to the new employer. There is a required action that needs to be taken by the new employer before the individual can start working for them. So it does require extra legwork because each petition is specific to the employer.
All right. So, Kimberly, what do you say on this? That does moving to a different location within the US for the same employer impact visa status?
Yeah, that's a good question, Sam. And again, I have to go back to it depends on the visa status. Like, what is the visa classification? For someone in TN status, a change in the worksite location within the US is not typically going to require any type of amended petition or reapplying for the TN classification. For the L1, it could require an amended petition based on whether it's an individual petition or based on a company's blanket L. So that really will depend on the specific circumstance. And then with an H-1B petition, as well as an E3 and an H-1B1, they are location specific. So it is totally based on the work site. If an individual is going to move, say from San Diego to Austin, Texas, then a new or we call an amended H-1B petition will be needed because that is a significant change in the worksite location. However, if someone is in H-1B status or H-1B1 or E3, and they change worksite location in this case, within San Diego County, it will not require an amended H-1B or E3 or H-1B1 petition, but there is a posting requirement for the labor condition application that needs to be satisfied before the change in the worksite location. So we always say before there's going to be a change, in the worksite location, just double check with the company, and the company should also double check with the attorney to make sure that everything is okay with that worksite location, that it may or may not require action to be taken. So you always want to check in advance so that there isn't any harm that's done with respect to company compliance or for individuals with an impact on their status in the US.
Absolutely. So, yeah. So, Kimberly, here's another question that I would like to know because today we are talking about changes in jobs of foreign nationals. So, this is a bit off topic. I mean, it's not specifically about the green card process or the visa status, but this is a question that most of our viewers they ask us, and they want to know that what are some high demanding jobs that are perfect for immigrants in the US. So I thought it's better to ask from an attorney because you can guide them better. Just a random, understanding or the advice that if they are looking for a career in US, then what can be some random jobs that could be perfect for them?
Oh, all right. That's a good question. Well, I would have to say that in the United States, we definitely need individuals with degrees that are in the STEM fields, right? Science, technology, engineering, or mathematics.
Mhm.
We see a lot of individuals going into positions in data analytics, business intelligence, as well as accounting. So accounting is one of those areas in desperate need in the U.S. We
Yeah.
have wonderful accounting firms and organizations here in the U.S. and they're not finding a lot of talent easily because not as many people are going into the accounting field. So that is definitely a career that is open in the U.S. And for individuals who are citizens of Canada or Mexico, there's an accountant classification under the USMCA, so that makes it a little bit easier. But that's a high demand field. And then we also see, believe it or not, architects, right? Especially landscape architects, civil engineers is also another one right now. So again, kind of the STEM field, accounting, we're in that area. Those are really careers that are in demand right now.
All right. I'm sure our viewers will get to know about it and they are going to love it. But also, Kimberly, I would like to ask from my curiosity that, now we are so much into AI. We all know that AI is, I mean, some people say that AI is going to replace most of the jobs. So, do you also believe this that it might happen that AI can replace some jobs? And if yes, then what can be those jobs?
Well, I mean, AI is definitely moving pretty fast, right? A lot of people are using it. One of the recent reports that I heard, and I might not have the specifics memorized, but it was something about 50% of white collar workers are using AI, but less than that on a daily basis. So it still isn't super widespread right now, but it is getting there, right? More and more programs have AI either as platforms or the use of AI behind them. So, in terms of will AI replace jobs? It will likely replace some jobs, but with one of the things I'm thinking about is as an attorney, like there's still that skill that's needed there that AI hasn't been able to, and we don't necessarily see it kind of taking over our jobs, but it's a helpful tool to
Mhm.
allow attorneys to do their job more efficiently and help with research, help you know make things take less time, right? So, but there's always having to go back and make sure that the information from AI is correct when you're dealing with some of those programs because it has there you've probably heard of some of the cases that have been made up that don't exist. So there's that
That's true.
component to it.
Hmm.
But AI has been, I mean, it's been great. We utilize it in our firm, as do many organizations. But I don't see it completely taking over jobs. Um, if it took over all of our jobs and it paid us to have vacation all the time, that would be great, right? But I don't see it going that way right now.
Absolutely. And I think, if AI is going to take away some jobs, then those jobs would be the daily monotonous task. That's pretty easy. That doesn't need some kind of creativity or that doesn't need a very different point of way to think because human touch have a very creative thinking, very different perspective. But that's not how AI works. AI works with more monotonous information that they provide, that already existing data, So I think, yeah, that's wonderfully explained. And thank you so much, Kimberly, for taking that up. That wasn't in our today's session, but still, it's in high demand in today's era that most of the people, they are thinking about it and just they wanted to know about it. So thank you so much again for taking it. And yeah, I think moving ahead, here's another question that if someone is in the middle of the green card process and gets a job offer from another company, then what are their options?
So that is a good question. And one of the things that we look at is what is the middle of the green card process, right? It can mean a lot of different things depending on that particular category for employment based sponsorship. So if we are in a situation where someone has their green card based on the PERM labor certification application. If we're in that PERM process and an individual changes jobs, then that PERM process stops and the new employer has to start the PERM process from the beginning. If we're doing, again, the PERM process and we're at the stage of an approved I-140 immigrant worker petition and the individual changes jobs, then the new employer has to start the green card process from the beginning again. But the benefit of having an approved I-140 petition is that the person can keep that priority date, which is essentially their place in line for the green card process. And they can also use an approved I-140 petition to obtain an H-4 EAD card for a spouse, or to obtain extensions of H-1B status beyond the 6-year maximum. So that can be beneficial. If somebody is, again, on a PERM sponsored green card process and they are at the stage where there's a pending I-45 application to adjust status, if that application to adjust status has been pending for at least 180 days, then they can port to a new employer. And as long as they're going to work in the same or similar occupation for which they were sponsored for the green card process, they would just have to file an I-45J supplement to notify the Immigration Service of their change in job, and they shouldn't have to start the green card process from the beginning. So that's with the PERM process, or the PERM-based process. If someone has, an I-140 based on an outstanding research or petition, and only the I-140 petition has been filed or approved and they change employer, they're going to have to start the green card process from the beginning. For an EB-1A extraordinary ability individual, if they self-petitioned, they won't have to start the green card process again, as long as they're going to continue to work in their field. And then with the national interest waiver, if it's a self-petition, again, as long as they're going to continue to work in that field of expertise, they wouldn't have to file the I-140 petition again under national interest waiver. If it was employer sponsored for national interest waiver, then we'd have to look at whether or not that national interest waiver field of expertise was based on something specific to the employer, or if it can be utilized nationwide. So those are some of the things that need to be reviewed in order to determine if the green card process has to start all over again if someone is, like, in quote, in the middle of the process.
Absolutely, that's how it should be. So, thank you so much, Kimberly, for explaining that in a very detailed way. And to our viewers, also, friends, if you are navigating immigration journey or having any doubts, or if you want to have uh, clarity regarding any topic that it's still stucking in your mind, then I think I would like to know that you can also connect with attorney Kimberley Best Robidoux, and feel free to reach out on the given contact details that are 619-826-4010. This is her call number. And you can also email her on krobidoux@wolfsdorf.com. You can also visit her website, that is www.wolfsdorf.com. So this was the contact detail of attorney Kimberley Best Robidoux. And I think moving ahead, I can also see, our audiences have posted some of the questions. So before taking that up, Kimberly, I would also like to come back to my questions, and would like to know about this thing that can an employer's decision to downsize or restructure affect an employee's green card application?
Yeah, so unfortunately, that is something that is going to be very specific to the organization, right? So if there's a downsize, we want to look at, where are we in the green card application process? So if there's a PERM labor certification application that has not yet been filed with the U.S. Department of Labor, that can definitely have an impact on the company being able to file the labor certification application, because if there's been a layoff, which is a downsize, within a certain period of time prior to filing the PERM application, then it might prevent the company from being able to file that PERM application. So that could definitely have a detrimental impact. If there's a restructuring, then we want to look at what is happening with the sponsoring entity. Is that entity essentially changing? So if the entity is changing, then that might require starting the green card process from the beginning, although in some circumstances, it might not require starting the green card process from the beginning. So restructuring is really, really dependent on the particular aspects of that restructure. Whereas a downsize, if there's a layoff, it can absolutely impact the PERM labor cert application. Does it have an impact on the 81A extraordinary ability or outstanding researcher or multinational manager or NIW? Typically, no. A downsize would not have a negative impact on those green card processes.
All right. So, also, Kimberly, there's another question that is regarding H-1B visa applicants because most of the people they are a bit afraid of, getting laid off. So, what happens if a foreign employee on an H-1B visa is laid off, and how long do they have to find a new job to avoid losing their visa status?
Yeah, so fortunately, we had a change in the regulations, which has been several years ago now. And what it does is it allows for a 60-day period of time, or it's up to 60 days, for an individual to change employers or essentially file another petition or application in order to stay in the US. So if someone is laid off on, we'll just do a date January 1st, they
Mhm.
have 60 days from that day to either have another employer file a petition to sponsor them for work authorization, or potentially for that individual to file an application to change status to a business visitor in order to stay in the US for a slightly longer period of time. So it's the 60 days. But the caveat with that is it's up to 60 days. And that means if someone is in a non-immigrant status in the US and their status will expire, meaning their I-94 document will expire before the end of that 60 days, then they only have that period of time to have a new petition or application filed on their behalf, or for them to file an application to change status to a visitor. So it's up to 60 days, and you have to look at the I-94 document, because if your status is, or an individual status is going to expire before the end of that 60-day period, then they only have until the end of the I-94 document to make that filing in order to be able to remain in the US. So those are some key factors to make sure to consider with, if there's a layoff, or if someone chooses to end their employment voluntarily and they don't have a job lined up before then, they would have until the end of their I-94 document, or up to 60 days as the discretionary period.
Absolutely, and I think viewers should be, staying informed with all the latest updates, and guys, connect with attorney, and know all the details that's happening around it, because that's how you are going to save yourself. And it's not easy, to work in US, and now, because it's H-1B visa, so there are some kind of restrictions as well that you need to follow. So yeah, I think go ahead and please talk about it. Take a help from attorney, from expert advice, from Kimberly also, and post your questions because we are definitely going to take them up. And the contact details of Kimberley Best Robidoux is mentioned here, so please go ahead and take it up. All right. So, Kimberly, here's another question that we have received from most of the remote working professionals and the past-time professionals. So, if an employee's role shifts to part-time or remote work, then how does this impact their visa or green card applications?
Yeah, so typically the green card application is for full-time employment. So having, remote or changing to part-time employment can impact the green card process. One of the things to really think about, though, or to consider, is that the green card process is prospective, meaning an individual is being sponsored for the green card and they become a permanent resident in the future. And at that time that their permanent resident process is approved, that's when they will be working in that sponsored position, in a full-time sponsor position. So if there's a temporary change in from full-time to part-time, that might not have an impact on the green card process if that person will be placed in that position for which they're being sponsored once they become a permanent resident. So that's one thing to consider when looking at full-time versus part-time. But typically, if it's a part-time position, that cannot be sponsored for a permanent resident status. If someone is in a non-immigrant classification, such as H-1B or E3 or H-1B1, and they are going to change from full-time to part-time, then that does require an amended petition. A new labor condition application has to be submitted to Department of Labor and certified, and then an amended petition filed with the Immigration Service before changing from full-time to part-time. So that's one thing to consider in that aspect. The same thing that people want to, look at if they're in optional practical training or they have the STEM OPT extension. If they're changing from full-time to part-time, well, part-time work might, very well be permissible under the OPT and STEM OPT regulations. There is a notification that needs to be provided to the international student officer. And when there's a STEM OPT, then the I-983 training program has to be essentially revised and submitted to the international student officer because of that change from full-time to part-time. If there's a change to remote work, it's going to depend, right? If the person is remaining in the same area of employment. So for instance, if someone is in, San Diego County and they're changing, from work in the office in San Diego County to working from home in San Diego County, then that typically will only require the posting at the new worksite location for purposes of the labor condition application. For individuals who are in a TN or an O1, if they're, changing from, sitting in the office full time to remote work, that typically will be permitted. An amended petition may or may not be required. But those are some things to consider when changing remote work, right? Where is that new location of employment going to be? So it isn't necessarily that it's remote work. It's more where is that person going to be sitting when they're going to be working remotely.
All right, that's great. And to our viewers, also, friends, you can also join this conversation by dialing on the number that is being shown on the screen. That is 425-4366335 with the access code that is 988888. So this is the great opportunity that you can have, and you can directly contact with our attorney today. And it's a great thing that you could ask your question, you can ask your doubt, or anything that you would like to know about your situation, your immigration journey, or your green card process. Kimberly is definitely going to help you out. And I think, yeah, Kimberly, we have lots of questions with us, as I can see. Trisha, then Krishna, and Sachin, Anusha. So, guys, welcome to Immigration and Jobs Talk Show, and thank you so much for posting these questions. So, I think, Kimberly, let's take firstly Trisha's question. So Trisha is saying that I was recently laid off while on an H-1B visa and my 60-day grace period is almost over. What happens if I don't find another job in time? Can I still stay in the US legally or do I have to leave immediately?
So again, that 60-day period of time is in the regulations. It extended what was a discretionary 10-day period of time to file a change of employer or another application or petition to remain in the US. So again, the I-94 document is what governs. So if the I-94 document is expiring before the end of the 60 days, person should not remain in the US beyond the expiration of the I-94 document because it kicks off unlawful presence in the US, which could ultimately result in being barred from the United States. So definitely keep track of that I-94 document. For an individual whose I-94 doesn't expire before the end of those 60 days to file a new petition or application, depending on someone's particular circumstance, they might be able to file a change of status from H-1B to B2, which is a visitor for pleasure, in order to be able to stay in the US for up to 6 months. They would have to be able to show that they have the ability to support themselves in the United States during that time and that they intend to return to their home country and they don't have, they're not engaged in any kind of employment in the US. So those are a couple of things that can be considered. Otherwise, the person would need to leave the US before the end of that 60-day, that 60-day grace period.
All right. So thank you so much, Kimberly, for taking that up. And Trisha, also, if you still have any follow up question or would like to know more about this topic, then please feel free to post them on the comment section and we are definitely going to take them up. Next, we have Krishna's question that is, my employer is restructuring and my job title and responsibilities are changing. I am on an H-1B visa. Do I need to file a new petition or amend my visa? What happens if they don't do it on time?
Yeah. So for the H-1B classification, when there's a corporate restructuring, the regulations are pretty broad, in that almost any corporate restructuring or change in the organization doesn't necessarily require the filing of an amended petition.
Mhm.
What can be done is filing or submitting, it's not filing, it's submitting an affidavit, which is prepared by the company. And it's an affidavit to the public access file in which the new organization or the new entity or the new division, whatever it is that's going to be, they become the H-1B sponsoring employer, has agreed to assume all of the obligations and liabilities of that underlying labor condition application for the H-1B classification. So if it's just a job restructuring, companies should always look to see if they can use that regulation and not have to file an amended H-1B petition. But if there is a job change, then that might require an amended petition in addition to that affidavit to the public access file. So it really is going to depend on the particulars of the job change. Is it significant that would require an amended petition? And then with the corporate restructuring, does the company, are they able to take advantage of that regulation and what they need to do is prepare that affidavit for the public access file in a timely manner. If it isn't prepared in a timely manner, then an amended H-1B petition is required. And in some circumstances, it might be that that amended petition is filed not as an extension of status in the US, but for consular notification. So worst case scenario is that the individual would have to leave the United States and return to the US with that approved amended H-1B petition and a valid visa stamp. So that's like the extreme situation that can happen.
Okay, I hope Krishna you got your answer. And still, if you have any follow up or would like to ask any other question, then please feel free to post them on the comment section. Till then, we are moving ahead with Sachin question. And he's saying that I am on an O1 visa and my project with the employer sponsoring me just ended. If I find a new employer, how difficult it is to transfer my visa? Will USCIS view the change as risky during the transfer process?
So if there's a change in employer for an O1, the new sponsoring employer has to file that O1 petition within 60 days of the last day of employment with the prior employer in order to take advantage of that ability to remain in the U.S. While there's a change of employer being processed.
All right. So next up we have Anusha's question, and Anusha is saying that my PERM process for a green card was filed by my current employer, but I have received a better job offer. If I switch employers now, will I have to start the green card process from scratch?
So if there's a PERM application that is being prepared or it's pending with the Department of Labor, and you change employers, that new employer has to start the green card process from scratch. Even if there is, an approved PERM application and then an approved I-140 immigrant worker petition, the new employer would have to start the green card process from scratch.
All right.
Unfortunately, yeah.
Unfortunately, but I think that's that's how it should be. So I think Anusha, I hope you got your answer. And Kimberly, here's another question that I would like to know from your end regarding L1. So how does job change will affect the employers on a visa like L1, which requires intra-company transfers?
Yeah, so a job change, if it's internal within the organization, we'd have to look at, is the individual going from an L1B specialized knowledge to an L1A manager or executive, in which case an amended L petition is needed. And it has to be filed with the Immigration Service before changing the jobs. If someone is in L1 classification and they are changing employers, then they need to look to see if that employer can sponsor them for another visa classification. So because the L1 is specific to the corporate organization, if an individual is changing employers outside of that corporate organization, then they need to have sponsorship for another visa classification. So they could look at things such as an E for a treaty trader or treaty investor if that organization, fits those qualifications, as does the individual. An H-1B, H-1B1 for citizens of Chile and Singapore, E3 for citizens of Australia, and then you also have TN for citizens of Canada or Mexico. An O1 might be an option. Or if that L1 employee is married to someone who, let's say, has H-1B status and an approved I-140 petition, that L1 worker might be able to change to H-4 status and get an H-4 EAD card. So it really depends on what options might be available if the individual is changing jobs from L1 classification.
Absolutely, it depends upon them. So I think, Kimberly, here's another question: that are there any specific visa types that are more vulnerable to complications when an employee changes jobs?
I mean, the H-1B classification can be difficult, especially if an individual is in an occupation that is one that the Immigration Service tends to not like as much. So it might require a lot more detailed information in order to show how it is that that position qualifies as a specialty occupation. So
Mhm.
that H-1B classification can be difficult, and we might see more challenges with the H-1B classification under a Trump 2.0 administration, especially if they're going to narrow, their view on what is a specialty occupation. Um, so that's one of the visa types. And also, even if an individual is staying within the same employer and they're in H-1B status, if they are, changing jobs within that same employer, that H-1B classification could be difficult as well. Again, based on the particular specialty occupation. So that one is probably the H-1B and the E3 are probably most vulnerable to complications if somebody changes jobs. The TN can be a little bit more forgiving if someone is staying within their same occupation. But again, if they're changing occupations or they're going from employee who's doing the work to maybe a VP, then that could have specific complications under the TN classification as well. So a lot to think about on that one, Sam. With any of the visa complication, any of the visa statuses, but I would say more likely than not, it's the H-1B that probably has most complications.
Absolutely. So, Kimberly, we are diving into today's topic, and brilliantly you are explaining everything. But I also want to know that Trump is coming back in White House. So I also want to know about it. That how do you see U.S. job market under Trump's administration?
That's a big question, Sam. So,
But our
you
viewers
know,
are very eager to know about it. They are so much curious and they are anxious also. So why don't you go ahead and let them know about the reality?
yeah. So, I mean, we're anxious about it as well. So, there are some concerns that with tariffs, that could, greatly impact our, economy here in the U.S. Which could potentially lead to layoffs at different organizations. So that could be an impact, and one thing that we are, definitely going to keep an eye on. There are also, with the incoming Trump administration, there could be an impact on the way that visa applications are processed, making it more strict and scrutinizing. But in terms of our economy, that one of the biggest things that we're looking at is an impact of tariffs on the U.S. economy. And if there's a downturn in the economy, then that means layoffs and unfortunately not as many job opportunities. I hope that doesn't happen, but that is definitely something to consider.
Yeah, absolutely. Nobody wants that to happen, but we can't say anything because Trump is unpredictable. So we just stay informed and have all the things in a very systematic way. That's only how we can save ourselves. So I think, yeah, thank you so much, Kimberly, for sharing your point of view also. And I think there are a few more questions that are left with. So let's cover them. And now I would like to know that, okay, this is the one that we took. Yeah. So can a job title change, delay, or restart the green card process?
So if it's just a job title change, right? If a company, and we see this a lot where companies are internally restructuring how, the titles that they give certain jobs, they might be moving jobs around their job families.
Yeah.
So if it's just a title change, typically we just continue with the process, right? Because it's a job title change. And what we're looking at is, are the job duties and responsibilities staying the same? Is it the same job? So what we've done in the past and consider to do, is if we're doing a perm application for a company and there's just a job title change, again, no change in duties or requirements, we would continue with that process using that job title. And that's if the prevailing wage request has already been submitted. Prior to that, we can totally change the job title with preparing the perm labor cert application. For most other green card processes, right, national interest waiver, outstanding researcher, extraordinary ability, multinational manager, if it's only a job title change, that's not going to impact the green card process. So that's some good news, right, with just the job title change. But if there's underlying change in the job duties, responsibilities, and requirements, then that will have an impact on the green card process.
Absolutely. So I think, yeah, and Kimberly, I would also like to know from your end that if an employer gets promoted to a managerial role, then is this going to help them fast track their green card under the EB1 or EB2 categories?
Yeah. So one thing that a lot of people might think is that if someone is promoted to manager and they're in the US in L1B status and are now being promoted to manager for L1A, it might mean that they are going to be eligible for the EB1C multi-manager category, but
Mhm.
only if they held a managerial role abroad for at least 1 year with the same organization. So that EB1C multi-manager category is very specific, but in some instances, it can really help employees because there are some people who are managers abroad and they transfer to the US in a specialized knowledge capacity and then they're promoted. So that could be really helpful. That can help fast track the green card process for sure. Um, Another situation, if someone is managerial, I mean, is it something where they have significant accomplishments in their career where now they qualify for extraordinary ability? That could definitely help in that respect as well. But I'm trying to think of other scenarios where it would have a tremendous impact, and typically not. If someone is EB2 labor cert based, being promoted to a managerial capacity might actually mean starting the green card process again. So while you can keep your priority date, it just means, unfortunately, having to go through that labor cert process again. So there's pros and cons, but there are a couple of situations where it can definitely fast track.
All right. So I think, Kimberly, we have successfully completed these questions that I have prepared. But now we have some of the more questions, that is being asked in the Facebook group. So
Mhm.
I would like to share that questions and would like to know about our more audiences who has been posting their questions on Facebook group. So here it's the question that, hello, does USCIS conduct home visits to verify the work location of a remote worker listed on the LCA during the background check as part of the I-140 filing process? I think due to some reason we got disconnected from Kimberly, but she's here. Yeah, Kimberly, can you hear us?
Yes. Can you see me?
Yeah, yeah, perfectly. Please go
Okay.
ahead.
Yep. Sorry about that. I don't know what happened.
That's
Um, Technical difficulties. That's what happens when we're live. So there's two things, right? The LCA, if we're referring to that as the labor condition application, that is for the H-1B classification. So in the H-1B scenario, the FDNS, which is the fraud division, does do site visits and they can show up at someone's home if that home work site is listed on the labor condition application for that H-1B classification or H-1B1 or E3. In those scenarios, an individual can say, like, I don't feel comfortable. Can you please email the company? I don't want to open my home. I don't know who you are. And I'd really appreciate if you can email so-and-so at the company. So that is something to consider. For the I-140 petition process, there is no fraud check on that with respect to someone from FD&S coming to do a site visit. We're just typically with the H-1B, E3, or H-1B1 classifications.
All right. So I think we can move ahead with the next question that is being asked from our viewers. And it's from Jayanti, and she's saying that, hi, all we have 14-month max out limit in our H-1B, but my husband company doesn't apply our PERM yet. What should we do? If you have any suggestion, please go ahead. Yeah.
Yeah, so that one can take a lot of time to kind of think through what the strategy and options are that are available. So depending on how far the company is from filing the labor cert application, if they are able to file within 1 year prior to the 6-year maximum, then the H-1B worker would be eligible for a 1-year extension of H-1B time, assuming that labor cert is not revoked or withdrawn or denied. There might be other options if the individual H-1B worker qualifies for an EB1 category and that they're currently not quota backlog. They might be able to file the I-140 and adjustment of status application concurrently, if that is a possible option if the person qualifies for that. And then we have some circumstances where if the labor cert is not filed at least 1 year in advance, sometimes we have situations where the H-1B worker will travel abroad and remain abroad for a certain period of time in order to be able to recapture the time spent abroad, so that by the time so that when you look at it from the perspective of when was the labor cert filed, plus the recapture time, the labor cert in that scenario would then have been filed at least 1 year before the 6-year maximum. So the extensions of H-1B status might be available. So it really is particular to the circumstance and where exactly in the process they are. Worst case scenario, we have in the past, unfortunately, had individuals who did have to go abroad and wait a period of time before they could come back in H-1B status. That's like the last resort. Attorneys try to find other options that are available, but those are some of the things to think through.
All right. So I think thank you so much, Kimberly. As you also said that it's a very lengthy answer, but still you tried your level best to complete it and make it as brief as possible. And I think most of the details you already covered. So I think that's how the answer is. And here we have another question that is a bit long. So, hi, currently I'm on H-1B and got layoff from my current employer. It's already 22 days now and didn't have luck to find new job. Moreover, in past also used 28 days grace period for another employee on H-1B. So my concern is how many total days grace period I have now to transfer my H-1B. Will I have more 38 days grace period or 16-day grace period for filing a transfer? If I go my home country and find a job, will my 60-day grace period stop? Is there any issue with transfer in H-1B petition if I am outside USA? Do I have to file petitions through lottery again? I have valid visa stamp until May 2024. Appreciate your help, please.
Yeah, so the 60-day period starts when someone is laid off. So let's say that someone was with company A, was laid off, and then found company B, and company B filed the H-1B petition within the 60-day grace period. Now the person is being laid off from company B and is looking for company C. They have 60 days from the day of being laid off with company B in order to find another employer to file the H-1B petition. If that is not found, if an employer is not found in time and the person has to go abroad, the 60-day grace period no longer exist. That 60-day grace period is only to file an H-1B petition or a change of status application in the US within that 60 days after having been laid off. So once someone is outside of the United States, there's no 60-day requirement that applies. But what would happen is that the new company would be filing an H-1B petition for consular notification. And as long as the individual still has H-1B time left, then they're not subject to the H-1B cap. So they can use up whatever remaining H-1B time they have left under their 6-year maximum. And that new employer can file an H-1B petition for up to 3 years. And then once that H-1B petition has been approved, then the individual can either use an H-1B visa stamp that they have in their passport from a prior employer if it still has validity on it, and they would use that visa stamp plus the new company's H-1B approval to re-enter the US. But if they don't have a valid H-1B visa stamp in their passport, they'd have to take the new employer's H-1B approval notice, apply for a new H-1B visa stamp, and then once that's issued, they can come to the US in H-1B status.
All right, that's great. So, Kimberly, I think it's almost an hour, that we covered, and I felt so grateful that we covered all our questions. Even all our viewers' questions have been covered. I think this is one of the rarest show, where all our viewers' questions have been covered, and they all got the answer. Not only the questions that we received from different platform, but also from Facebook group as well. So I think that was wonderful. You were to the point, you were outstanding and clear, practical, and yeah, to the point, obviously. So I think I honestly I enjoyed this session a lot, and I'm sure our viewers also loved this session and they found it very fruitful and amazing. As you also shared the real life examples. So I think that was brilliant. And any last message, Kimberly, that you would like to share with our viewers on today's topic, or anything about that you just would like to share with our viewers and want to let them know about?
Yeah, my approach is always ask and find and discuss a strategy before making any changes, right? Knowledge is power. So always ask, get that information, and then go from there in order to make a decision. And absent that, happy holidays to everyone, and happy holidays to you, Sam.
Oh, that's so sweet. And happy holidays to you too, Kimberly. And I'm sure that you're going to have a blast in Christmas because I know you already shared your plans. So that was great. And I know you're going to enjoy it. And to all the lovely viewers also, please, utilize this time. It's Christmas time and have fun. And thank you so much, Kimberly, for your time. It was really amazing and it was really informative. And this discussion was, I loved it. And I hope we will have more discussions and more sessions together in our future. But also to our viewers, friends, if you're navigating an immigration journey or have any doubt, or have any question or want to connect with attorney Kimberly Best Robidoux, then feel free to reach out on the given contact details that are 619-826-4010. You can also email her on krobidoux at wolfsdorf.com and visit our website that is www.wolfsdorf.com. So don't forget to join our upcoming shows as well. And as always, stay informed by liking, sharing, and subscribing to Immigration and Jobs Talk Show for more updates. Thank you, Kimberly, for being here. It was a pleasure having you. And thank you, everyone, for joining us. I'm Sam signing off for now.
Thank you so much, Sam.
Thank you so much.